Hello, everyone. My name is Andrew Delzato. I'm an associate in Bond's Labor Department and based out of the Westchester office. We just finished a great program on our weekly webinar where I gave some updates on a series of recent federal court decisions that have affected the Department of Education's ability to enforce an executive order that seeks to crack down on DEI programs, policies, and initiatives in the higher education and K through 12 education space. I'm sure many of you will recall that in the first wave of executive orders under President Trump back in January, there was one entitled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. This one got a decent amount of media coverage at the time, but it really wasn't until mid-February that the new Trump DOE turned up the temperature and began signaling that enforcement was imminent for institutions that didn't fall into line. This came in the form of a Dear Colleague letter that was sent out again to K through 12 and post-secondary education institutions. The letter makes it clear that institutions that continue to advance quote unquote illegal DEI, which is not actually defined in the letter or the executive order, will jeopardize their receipt of federal funding, which includes federal financial aid. So by the end of April, two U.S. district courts issued orders narrowly restricting the DOE's enforcement efforts. The first case was brought in the United States District of New Hampshire. In this order, the court found that the plaintiffs in that case had shown that the letter was so vague that it denied due process, suppressed legitimate speech in violation of the First Amendment, and also violated the Administrative Procedures Act because it didn't follow the proper notice and comment process for rulemaking. So the result of this was the court finding sufficient evidence to grant a preliminary injunction. So while that looked great on paper for all institutions across the country, the scope of the injunction only applies to enforcement actions against these particular plaintiffs and any entities that are actually in contact with them. On the very same day as this New Hampshire decision, the U.S. District Court for the District of Maryland issues what's called a temporary stay in a similar case, and it's sort of a similar legal tactic. This temporary stay prevents the DOE from enforcing the challenge provisions of the letter that go beyond existing law. So the DOE still can go ahead and enforce laws that are on the books already. While this temporary stay is a little bit broader than the New Hampshire court's injunction, again, it recognizes that during the litigation, the DOE may undertake enforcement actions in accordance with existing law, so they just can't go any further, essentially. While these grants of temporary relief are a setback for the DOE, which has not appealed these decisions as of today, June 3rd, it will certainly continue to enforce its agenda wherever it can. Even if the courts ultimately strike down most or all of the letter or the contents of the letter, it could still move to clarify the regulations via the proper notice, comment, and rulemaking process, which typically takes months or even years to complete. All this basically means that the path forward in this area is still uncertain, which makes consultation with legal counsel extremely important. Luckily for you guys, bond attorneys are following these and other legal developments closely. This topic is only one of the ones that we covered today, so I encourage you to view the full recording and subscribe to the series on YouTube to make sure you don't miss any future updates from bond attorneys. So with that, thanks, and we'll see you next week.